I'm going to finish up reading the Mueller Report Volume II. It's my favorite section on making the case for obstruction of justice. I ended last time at item 104, where, taken from the book, Mueller states, other obstruction might apply to the conduct in this investigation. However, Mueller laid out his case for Congress to act based on the merit of the case law. The president has the obligation to take care that the laws be faithfully executed. His behavior makes a mockery of our laws and the Constitution. Those powers and duties form the basis of prosecutorial discretion. The president's powers coexist with Congress when they do not coexist to protect we the people from a president who obstructs justice and has intent to harm grand jury proceedings and other investigations. Then the two branches of government must separate. I'd like to read that again because that's most important. The president's powers coexist with Congress when they do not coexist to protect we the people from a president who obstructs justice and has the intent to harm grand jury proceedings and other investigations. The two branches of government must separate. The law is clear. If the president, in his official capacity, attempted to impede, interfere, or influence the outcome of an official proceeding or inquiry, any committee or subcommittee is empowered in either house or jointly to bring an action of obstruction of justice. Therefore, Congress can regulate the president's actions without harming his official capacity. Congress may criminalize certain obstructive conduct of a president if he is bound to be subjoining perjury, intimidating witnesses, or fabricating evidence. All these occurred time and again. The separation of powers principles supports the conclusion that Congress may validly prohibit corrupt, obstructive acts to be carried out through the president's official powers. Page 171 or 383 of the entire Mueller report concluded that Congress may make a case for obstruction of justice without harming the president's Article 2 functions. That's the case, page 171 or page 383, depending on whether you're reading Volume 2 or the entire PDF. The Supreme Court's separations of power balancing test applies in this context. The Supreme Court has upheld that they are entitled to archival presidential records despite a claim by the president of privilege. The Supreme Court has upheld that they are entitled to archival presidential records despite a claim by the president of privilege. Additionally, even when we take the many powers of the president into account, Congress powers in its separate role of lawmaker gives it substantial authority to determine if the president's policy was just and proper. Congress may regulate the president's ability to act on his policies, if not on his ability to function. Page 173 or 385. Nothing in the Constitution says that the president may use the power of a pardon to act corruptly or falsely. Congress has the power to prohibit the corrupt use of anything of value or to influence the testimony of another person in a judicial, congressional, or investigative proceeding. Noting the law 18 U.S.C. Section 201(b)(3, which includes the offer or promise of a pardon for providing false testimony or no testimony at all, the offer of a pardon would precede the act and thus be within Congress's power to regulate, even if the act of pardoning is not. Therefore, this too falls under the purview of the obstruction of justice statutes and does not interfere with the separation of powers. According to and support of, the Supreme Court has found no instance where charging a president with obstruction of justice interferes with a president's powers. The president has no more rights than an ordinary citizen to impede official proceeding by corruptly influencing witness testimony. Page 173 or 386. The conduct is improper. Congress as a body has failed to regulate the removal or the qualifications of members of the executive branch. There are no job descriptions for the president and his cabinet. Cabinet members may be crooks and thieves, have conflicts of interest, and even destroy the institutions they were sworn to uphold. There has never been a limit imposed on chicanery. Very interesting, though Congress may not remove or add senior officers or cabinet members, they may appoint junior officers to oversee cabinet members as stated in the Constitution. Inferior officers are the head of the FBI and special counsel, each of whom reports to the Attorney General. The Congress has the power to protect congressional, grand jury, and judicial proceedings against corrupt acts from any source. Therefore, Congress is entitled to a totally unredacted copy of the Mueller Report. It's also entitled to act against people who were pardoned illegally. It's entitled to a lot, and it can also now appoint junior members to oversee cabinet ministers. Congress is not powerless. Let's see if they act. There is no argument this is a proper request to safeguard the law and with Congress's purview. The obstruction of justice statute necessitates that all material be made available to protect, among other things, the integrity of its own proceedings, grand jury investigations, and federal criminal trials. No one wants to go to the lengths of charging the president with obstruction of justice. However, unless and until they do, they are not entitled to a full, unredacted copy of the Mueller Report. We don't need to spin our wheels to prevent name-calling of the House as partisan Democrats. To preserve the rule of law and the integrity of our democracy, we, the people, must take a stand for justice. In our own defense and for our own salvation, we must call for impeachment on the grounds of obstruction of justice. Both going back to 1831, there is a long precedent for maintaining the rights of Congress to act appropriately to save its own legislative functions. It may act against a president who would impede fact-gathering and law-making efforts. Congress also has the power to protect the judiciary from obstructive acts by the Attorney General. In the Supreme Court case against Nixon, the need to safeguard judicial integrity is a compelling constitutional imperative. Note the denial of full disclosure of the facts surrounding relevant communications of the president threatens the integrity of the judicial system and public confidence in that system. Ultimately, justice will be done. Richard Nixon's AG, John Mitchell, was found guilty of obstruction of justice. He blocked the release of the Pentagon Papers and was found guilty and sent to prison. Mueller writes that we are entitled to see the grand jury investigation to determine if others should be indicted. That's vital to the criminal justice process. It's imperative that we, the people, support the actions of the House Judiciary Committee. To do less after knowing the facts would be a crime. After reading Mueller's legal brief, I am convinced that everyone in this land must call upon Congress to commence impeachment proceedings. No less than our democracy depends upon this. Page 183 or 395 begins the Appendix A, and Mueller concludes his investigation after approximately 2 years, which began on 5/17/17. Appendix B is a glossary of reference persons, organizations, and acronyms, all worthwhile refreshers of information and an understanding of the scope of the Mueller report. The Russian connections outweigh the American principles involved. Appendix C restates Mueller's strategy. It appears from the redaction on page 418, Trump is the subject of grand jury investigation. Mueller considered issuing a subpoena for his testimony, but wrapped up the case instead. He knew that he had enough information from other sources to allow him to draw relevant, factual conclusions on intent and credibility, which are often inferred from circumstantial evidence and assessed without direct testimony. As part of Appendix C, there are written questions asked of Trump, to which he must respond under oath. Besides the legal roadmap setting up the validity of an impeachment proceeding for obstruction of justice, Appendix C's questions of the presidents are a legal route to discovery. These questions are mostly answered under both Volumes 1 and 2, referring to Russian collusion and the case for obstruction. We know from corroborated testimony that Trump's answers to the Mueller's questions on the June 9th meeting were lies. Appendix D, page 444, states, harm to ongoing matter, titled, Investigation Ongoing re Manafort and His Connections with Ukrainian ex-president. Information on Roger Stone is redacted. Referrals to the FBI can be gathered independent of the AG by Congress because the FBI are considered inferior members of the administration. Of the 14 people referred to the FBI or other appropriate law enforcement entities, criminal activity was identified, but outside the scope of the special counsel. 13 persons are rejected by Barr, the current AG. My conclusions? Congress should continue empowering the grand jury and seek all relevant testimony. Congress should impeach Trump in order to obtain the total unredacted work product of the special counsel and ultimately seek justice for all Americans. The scope of Mueller's investigation is enormous and encompasses approximately 140 individuals, of whom 70% are Russians. And this concludes Volume II of the Mueller Report. I saw Nancy Pelosi on January 21st, 2019, at a meeting at the AFL-CIO headquarters and tried vigorously to get her to impeach Donald Trump based on the findings of the Mueller report. I came away totally disappointed, knowing she was never going to use his work product. She should have, but didn't. And here we are, years later, asking ourselves, do we really want a kleptocracy? Do we really want a judiciary that sides with the imperial president and indeed made an imperial president? And that both branches of government are corrupt and taking money from we the people and have conflicts of interests? When do we say enough? I say we've got the midterms in November. It's time to change Trump's agenda and go back to law and order for everyone and justice, equal justice for all.